Morning. It's
Morning.
Thursday, February 13th. And we are going to spend some time today on education finance for a change. So we're gonna start with a committee bill that I asked Kirby to draft, which is essentially taking the report on reappraisal reform from the Department of Taxes and making it into a bill. And then hear from Julia about some data on grand list values that's related, that's sort of laying the stage for the governor's proposed state guarantee, which we're going to talk about at 10:45. And then after lunch, we had some rescheduling and we are doing pressures on the general fund with regard to education finance with Emily Byrne from JFO. And that is our day together. Kirby, you want to join us?
Morning,
Morning.
bright and early. As the chair mentioned, Kirby Keaton, Legislative Council. As the chair mentioned, we have committee bill draft based off of mostly the recommendations from the Department of Taxes and its Act 68 report. It should be available for you on the committee webpage. Launch into
Walk us
it.
through it. I'm sorry. I'm not prepared with all my prompts today.
Okay, so in this draft bill, we're creating a new subchapter in one of the chapters relating to property valuation. There are 5 or 6 of those chapters.
I found one of my prompts inside my head, if I could share it. Thank you. Given this is our first time walking through legislative language that we might do something with, I think, this session, I would encourage us to do our very best to save big picture questions till the end and just seek to understand what's actually in the language for now. And that might mean letting Kirby finish a whole section before we ask questions. As a committee, we never, ever wordsmith legislative counsel while they're sitting in the chair. Some committees do that sometimes. We do not do that. If you have an impulse, write it down. We can talk about it after. Okay, with that, Kirby, thank you.
And if you have lovely words for me, yes, you can share them
You're amazing.
outside the room and we can consider those words. Okay, so we've created a new subchapter, which is to handle statewide property assessment, because that's the idea that Vermont would move toward that. We start that subchapter with legislative intent, which becomes important for the subchapter because there are a lot of unknowns that PBR talked about in its Act 68 report. And we have a section down below where PBR will be kind of sorting those things out in a flexible way going into the future to try to coordinate this regional property assessment. But PBR would be guided by this legislative intent section. So that's why we have that here. So far, it's kind of short. It's the intent of the General Assembly in creating this subchapter. 2, 1, or to create regional assessment districts, because that's the idea of this, so that property values on municipal grand lists are kept up to date and accurate. 2, property data collection is consistent and standardized across the state. This has a lot to do, if you remember VCGI's testimony, a lot of that was about this very thing, just having property data. So the entire presentation that VCGI gave and that some others gave is wrapped up into the concepts here. And the third subdivision on legislative intent is that property valuation is considered or is conducted by professional staff. So those so far are the guiding pieces that we have for PBR and running these. And then that brings us into the establishment of these newly created regional assessment districts. I will call them RADs. That's our new acronym. It goes forward. You can get used to that. So we're going to have 12 RADs. that are based mostly on the county level, except that Franklin and Grand Isle will have one RAD and Essex and Orleans will have one. One part of the Act 68 report was that the data and analysis and the consultants used for IPVR landed on to make this economically viable to take advantage of economy of scale. Vermont should be doing reappraisals on at least 10,000 parcels at a time. So breaking it up this way gets us to over that number. For each of these counties or 12 RADs, they would have more than 10,000 parcels. They would be mostly roughly the same in parcel count under their jurisdiction, except for Chittenden County, which has a lot of parcels. Okay. So after that, we have some organization for the RADs. So each would have an assessment supervisor that's appointed by the Commissioner of Taxes. This is important because this firmly establishes that these entities will be operating under the control of the Department of Taxes. The heads of these 12 entities could be hired and fired by the Commissioner of Taxes. That becomes important because there's not a lot of rulemaking in this. It's more like an interdepartment operation where they're deciding their policies internally with the idea that they're going to follow that legislative intent and make it standardized across the state. So that's kind of how it's set up. It could be set up different ways. It could be set up with some more bureaucracy or more use of regulatory rules. And it's not really done that way. It's done so the commissioner's kind of running the operation guided by what's in statute here. And we do have some provisions on what the assessment supervisors will be directly responsible for. So you see here on page 2, starting at line 14, the assessment supervisor will be in charge of supervising and administering the operation and implementation of all duties of the regional assessment district under Vermont law. That's written very broadly because, as I think I mentioned before, there's several chapters relating to valuation, property tax exemptions, etc. So there's going to be a lot there. They'll also be in charge of assisting PVR with the director's duties relating to property valuation, data collection, and grand list maintenance. That includes the organization study and a lot of the things you've heard about recently about having standardized data collection for the grand list. So that relationship's established where the PVR director and the assessment supervisors are directly responsible for making sure the data is accurate and that it's collected in a standardized way so that we have a lot better grand list data. The third thing they'll be responsible for is employing staff. Again, guided by the legislative intent that we will have professional staff, especially those conducting valuations. And the fourth subdivision here is that the assessment supervisor will prepare a budget. I took this from how the Cannabis Control Board was set up. They have an executive director who prepares a budget. I haven't had any discussions with the Department of Taxes. I had some discussions for parts of this going into it, but I've not received full feedback on the whole thing from them. So you might receive, some feedback about things like this, about whether, administratively having this assessment supervisor establish the budget may or may not be what other people in administration thinks is a good idea, but it's in there.
And I just want to be sort of big picture that I did not say at the beginning, framing this. The reason this is an important, from my perspective, the reason this is an important part of educational finance reform is that in order to have fair property taxes, we need to have consistent appraisals around the state, right? And maybe that goes without saying, I just want to say it anyway.
Preparing a budget. Who oversees the budget? Department of Taxes.
So there's a couple of things that are not included in the bill right now, some big things. One of them is the appropriations and the setup, the FTEs and so forth for this system. I think we'll probably need to hear testimony from the department and from PVR about what's needed to set that up. So at this moment, We do not know where all the money's coming from. The assumption would be from an appropriation from the General Assembly. There are some things currently in law, which we will get to here, that provides some funding for this. There's the per parcel fee that municipalities are paid currently by the state. That's going to be redirected to the regional assessment districts because they're taking over those duties. In case it's not clear so far, there will not be listers. There will not be municipalities in charge of this work. This will be done by the regional districts. So any funding that's going for that purpose now would be redirected to the districts. But that's not going to probably be enough. I mean, maybe I shouldn't comment on that, but it just doesn't seem like it.
And we can and all of that can be changed, right? Either based on sort of a level of administrative advice from tax, or we think it needs to be structured differently. This is an outline to begin with.
I see that it's an outline but when I think to myself, will there be enough funding? Then I just don't want this to be an unfunded mandate to the municipalities, so.
Well, this is actually taking work off the municipalities, yeah.
Yes. There's,
Yeah.
that's up to you.
Representative Odie, before you joined, I laid out sort of this is the first time we've gone through a bill this biennium in committee that we're working on. And so hoping we can all sort of big picture seek to understand for the first go round, and then have ideas on the second go round.
But I think to answer your question more directly, the Department of Tax's budget is where a lot of this may end up coming from. Okay, I don't think I mentioned subsection D here, which is just saying that the assessment supervisor or the RADs may contract with third parties to conduct reappraisals in that jurisdiction. That provision is just to make it expressly clear that that's kind of the idea, is that we'll have mass reappraisals that save money. Okay. The next section for this new subchapter is on standard guidelines and procedures established by PVR. This is the section that handles a lot of the unknowns out of the report. If you recall, the department had suggested waiting a year or two. I think the department seemed in favor of the idea here, but they wanted to wait a year or two to get stakeholders together to figure out some unknowns. Well, instead of doing that, we have these guidelines and procedures that PVR is to develop in the future to make sure everything is standardized, and where they'll be settling out those unknowns that they wanted to wait and do through a stakeholder group. Put differently, nothing in here is stopping PVR from doing that process they wanted to do. If they want to convene stakeholders informally and to inform these guidelines and procedures, they can do that under this language. So PVR will be developing these guidelines and procedures. They aren't rules, by the way. Rules have the force and effect of law, and they take a very long time to set up and bring through our process for approving of rules through the administration and through the legislature, right? This is more informal. It's more flexible because they can be adapted without having to wait a year or so to update. There's not public input necessarily in this kind of process like there might be with rules, but this is more of an internal how you're running your agency kind of decision that rules don't always really do anyway, right? Okay. So what will these guidelines and procedures cover? It says including, so it could be other things, but at a minimum, there will be rules for contracting with third parties to consider or assist with reappraisals, including standard reappraisal contract terms. All of these things I'm about to say, by the way, are out of the Act 68 report for things that PVR wants to be able to do. The second is standards for collection and recordation of parcel data. Among other things, this encompasses everything that VCGI wanted to do, or at least that's the intent when I drafted this. And the third is requirements relating to information technology, including standards for data software contracts and CAMA systems. So under this language, for instance, PVR, if they thought it was the best course, could require the same CAMA system be used in every district. And maybe even have a contract to save money so that every district gets them all at the same time, something like that. So those are the kinds of things that PBR can work out and that are probably better left for the agency to figure out on the ground as opposed to us trying to put those details in the statute. Subsection B has PBR establishing a schedule for each regional assessment district so that we'll conduct a full reappraisal every 6 years for each municipality in its jurisdiction. The 6 years number was put into Act 68. It was to be analyzed in the report under Act 68, and feedback was that 6 years is a good number for Vermont. I'm paraphrasing the report there, but it seemed like 6 years was workable. The consultant's report, the IAAO's report, had 5 to 8 or something like that. So it seems like 6 landed in a workable place. So we have 6 there. And then there's some flexibility where the director may alter RAD's reappraisal schedule at their discretion. And that's to account for things come up, especially at the beginning when this is getting off the ground. There's going to be a lot of logistics in setting up these first mass reappraisals in all the different districts. But even as things get going, there might be, events that happen that might require some deviation. So then we have subsection C, where this is our first indication that this bill also establishes a new timeline, which is part of the Act 68 report, to have January 1st as our grand list date, to set the grand list, as opposed to what we're doing now, which is April 1st. So this February 1st is in line with that. On or before February 1st, PBR shall furnish the RADs with the evaluation of all taxable property of any public utility. This is something from current law. We're just keeping the process in there. And where we could, we're keeping any kind of oddball or side niche things under current law. So the way the public utility valuation is done is being kept the same. It's just that the date for it is changing to line up with the January 1 grand list date. And I'm going to say, I might miss dates throughout here, so I'm going to rely on the department and the people who are doing this for their day job stuff to help us out to make sure everything lines up. Okay. Subdivision 1 and 2 and 3 on the screen here are all from current law about public utility valuations, so I won't go through that. And then it brings us on page 4, starting in line 17, to a section I included, which I'm hoping to get feedback on. This is what the regional planning commissions are able to do right now, where there's a section of law allowing for them to go get funding other places, potentially like grants or funding directly from a municipality. Because of Vermont being a Dillon rule state, you need things like this in order to enable municipalities, if they want to throw some of their own money toward the RAD, then they can do so. And so it offers some flexibility for paying for reappraisals and paying for the work the RADs are doing, that in the real world may or may not exist. Maybe in the planning world, there's a lot more grants and it makes sense for regional planning commissions to have this flexibility. Maybe under the system we're setting up here, it turns out that this is not a section that's going to be used. I'm not sure at this point. And that brings us to the next section, which is the next 2 sections in the subchapter make up one entire chapter of law right now that will be repealed. There's
I think before we get to that, maybe let's pause.
Okay.
Does anyone have any questions to sort of understand this construct before we go into the whole appeals chapter?
For the every 6-year timeline, is the intent that the RAD would create the schedule so that every town was indeed reappraised every 6 years? Or is it every 6 years, all the towns have to be reappraised?
the way it's, I understand your question. The way it's drafted is that PBR will establish a schedule for the RADs. It's written in a way right now where PBR could interpret it either way, whatever way makes sense. If throughout this process we discover that, there is actually a certain specific type of schedule is desired, this can be changed, of course.
So so just, so for example, if a district had a terrible event that completely destroyed the value of their local property, they could petition for a review on a shorter schedule.
Yeah.
Okay.
So.
Right, but it would be.
Right, that's that provision on the flexibility there for unforeseen things like that.
And can I ask a quick question about how the funding would work? First of all, thank you. This is amazing. And it's really exciting to be working on this, but on the funding provision, is there a risk that creating the possibility to raise locally might preclude the responsibility of the department to raise? Or is that not?
You ask that question again?
Well, this creates the possibility that regional assessment districts can apply for, receive, and expend monies from any source, blah, 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 blah. My question is, if this is supposed to be in the Department of Taxes, do you want local independent access to revenue that doesn't come through or isn't moderated by the Department of the Taxes?
I had that same question. I think it's a question to ask the Department of Taxes, actually, because whether they might already be able to, the idea is just to be able to get grants, right? And so it's a question of whether or not we need to add that extended permission, or if that permission would just sit at the Department of Taxes.
Whether the granting entities would target only the districts or the state government. Got it. Okay, so they'll,
But it's a good question to ask tax when they come in.
okay.
And the reason, Herbie, for moving the grand list date from April to February, what was that?
I'm probably not going to be able to comprehensively answer that. I think that PBR has a lot of reasons for doing that. I think it's to enable other things that are hooked up with the grand list, like property tax credits, homestead declarations. It could set up the state to better handle some other like associated issues.
I know there've been issues with that for a long time, so, okay, will this solve those? Just moving the date?
That plus more legislation, plus more fixes potentially, but it sets us up. And just like, the chair had mentioned before about this also sets us up to do other things for property taxes, our property tax system. If you have good data across the state on your properties and it's consistent, then that allows for other options for taxation. We know that we're currently limited in some of the flexible things the state could do or the General Assembly could do. Because, for instance, property classifications in one, like right now it's done without standards from town to different listers. So in one town, a property could be called residential and the next town over could be called something else. Like we know that comes up. And so that means that we can't really do anything with property classifications in our tax system because we don't actually have good data for that. And I think that VCGI also mentioned some other reasons why they would like to see, good property data for the work they do.
Okay. And all good questions to ask Jill when she comes in again on the report. Yeah.
Couple questions. One is you said the concept was that listers would no longer exist. Is that further down in this draft bill?
Yes, and there's also some more work for me to do with what we're looking at right now for language is the substance of the big changes we're doing. Right now it's 21 pages. Once I make all of the conforming changes to replace the duties of listers with the RADs and changing dates in places where it's necessary to do so, just to give you a heads up, this bill will become much larger to conform to this structure.
And again, on the appropriations, because currently, was it $8.50 per parcel goes to pay for the reappraisals? So,
And that's in this bill.
it's in the bill. Right now, the towns are on the hook for 50% of the cost of the reappraisals, right?
It's sort of more, there's like a bunch of stacked money that lets.
Right, there's $1 per parcel for maintenance of the grant list and then the $8.50 for the reappraisal. So it'll be interesting to get to that section in more detail.
So I'll give you the big overview of how appeals will be done and spare you the details unless you want to go line by line with them. Much of it's current law that's just. The appeals process, and this is again, what was suggested by Act 68, would have what is now, so currently, the listers will, during a time period each year, have a grievance period where, property owners can come informally to local office and ask for clarification or ask for a change to, their grand list value, or some other specific thing about how the valuation worked. That won't happen because there won't be listers. Now it will be the regional assessment districts who will, for each municipality that's under their jurisdiction, they'll set aside some time, and I will go into that language when we get to it. But I'm just trying to give you the whole system overview right now. They'll set aside some time for people to do that same process, except it's just not going to be lister grievances, it's going to be grievances with the RADs, and it will be an informal process. If people are unhappy with that, they'll be able to, just like under current law, appeal it. Under current law, though, it's appealed to the Board of Civil Authority. Now it will be appealed directly to the RAD's assessment supervisor, who will then set aside time, conduct their own hearing for that, kind of like the Board of Civil Authority does, and make a decision. That decision can then in turn be appealed to either PBR or to the court. PBR currently has the ability, when there's an appeal made to it, can say this is not a good fit for us. We're going to just forward this to the court anyway. That remains in here. The big difference for the PBR system is currently the law is set up so that PBR has like part-time hearing officers that are third parties who don't work directly for PBR. And that system has created some problems. And I think that Jill has been in here often talking about how it's hard to attract people for this. It's like, it's low pay. These people need to be highly qualified, but we're not, but we have 5 or 6 people who are working only on a few cases at a time. And it's just hard to operate. And so the suggestion under Act 68 was to professionalize the hearing officer. So what I've done in this bill is set it up similar, like for, the Department of Taxes has a hearing officer for other tax issues, right? But in the law, it's just the Commissioner of Taxes is responsible for administrative procedure. And that's not something that's expressly, this hearing officer that they use for this isn't something expressly created. So I made it like that. Made the Commissioner of Taxes is responsible for the PBR appeals. And so it goes without saying, they can hire a professional property valuation expertise hearing officer to do these things the way it's set up, is the idea anyway. And you know, we may get feedback about that. So it's set up like that. And then the part to the court is exactly the same. And when these appeals are made, just for background info for you, to PBR or to the court, they're heard de novo, which means anew. Any decision before from the RADs, any factual determinations, any interpretation of the law by the RADs, none of that's going to go in, is going to be factored in. It's going to be completely fresh start when the department hearing officer or the court looks at it. Okay. So now that we have that big overview.
Representative Odie?
Thank you. Just that remains informal. You don't have to have a lawyer or anything like that. At the appeals stage to the PBR, probably
You
not.
don't have to have a lawyer ever.
Well, so it's very informal at the RADS stage.
At the RAD stage, very much informal, yes. Once the appeal goes to PBR and it's an administrative hearing that follows all of the procedures that Vermont requires for administrative hearings, and the fact that this requires technical expertise and evidence, unless it's for a very small amount, like a person's going to probably want, or any, not only an attorney, but maybe even outside assessment expertise.
So. That's a little
Mhm.
much.
So if you're gonna appeal, you go to the RAD supervisor first.
Well, you go to the RAD staff at the grievance hearing,
Okay,
and
It's
then,
informal.
and that's informal. There's also a process for, I talked about the grievance, but there's also a process for when evaluations change in the middle of the year, which sometimes happens, that you would appeal directly to the RAD supervisor.
okay, but then if you're not satisfied, then you can go to either PVR or the court.
Mhm.
Similar to what it is now.
Very similar to what it is now, except that it's just different staff. The goal is having more professional staff at every level of this, except for the court, which stays the same, but having more expertise, more professional people dealing with these each way along the way. And so dealing with these appeals is one part of all the work that the RADs and the supervisors will be in charge of.
Representative Woody?
Is there such a thing as like an outside, you said they might need outside assessment expertise and a lawyer. Is there such a thing as having somebody who would be another source of expertise outside that people going through this process could rely on? This is like a big deal.
Mhm.
So I wonder if there's a way that people could say, well, it's okay, you know, I can have this resource for me.
Representative Woody, I think the Office of the Taxpayer Advocate is sort of available as a resource for people with that, but I feel like you're moving into problem solving.
Yes, I am.
Okay, let's stay on understanding the topic.
I'm thinking about Act 250 also and how
Yes.
it's supposed to be.
This is- yes.
you know,
Yes.
friendly, and then it turns into something harder, and then I'm thinking about consistency across the state, and thinking about a lot of things.
Cool.
Right.
Good.
Yes, so that is the overall framework for the appeals process in the bill. Some dates are changed from current law. Generally, the windows for appealing decisions for the taxpayer are changed in a few, giving them 30 days instead of 14 under this. Under current law, it's 14 days. And then if you miss that window, you may miss your chance to have someone look at whether a mistake was made for your property. So we're extending that to 30. But in places where, so you'll see here, 30, but in places where the government has to act, it's staying at 14 days to keep that timeline going.
We didn't read the whole thing word for word, so is that at the 6-year time, everybody gets their new appraisal? And then they have 30 days from that, or it seems like that's what it would be.
At this point, I'm not sure if they'll do the entire county every 6 years or if they'll stagger it in some way. And I don't know how that will go, but let's assume that yes, for a municipality, there was a reappraisal. And so the first opportunity that a taxpayer would have would be the grievance period where the RAD is available in that town. And you go and you try to work it out. And going to your point from before, I mean, a lot of the system relies on the good faith of these professionals. So if a person goes and says, you thought I have 2 kitchens, but I really don't. And you could offer some proof of that, then you're trusting the professional to say, you know what, I'll change that in the system. And we'll run it again and see if that works differently for you. I think that's why we have that informal process, is to those little things to get sorted out. If you go and say you have, you know, if the same thing happens, but the RAD staff do not agree, and they don't change it, then you would have a time period where you can appeal to the assessment supervisor, their boss, who can then take a closer look and hold a hearing, give you a chance in a slightly more formal setting to make your case. And if that still does not work out and the taxpayer is unhappy, they can appeal. There's also, I think with that, I am gonna walk through the pieces. I think we have the overview. I'm gonna walk through the pieces because there are complicated parts. Okay. So we start with some current law that's adapted, and if you want to follow along or compare it to current law. This is in what's now the appeals chapter. Okay, so within 30 days following the date of notice, a person aggrieved by a decision of the RAD under 4221, that's the grievance. Which is currently the Lister grievance, which is being changed to grievances that the RADs hold. They may appeal to the assessment supervisor. The assessment supervisor shall schedule a meeting to hear and determine appeals made under this subsection. They have 14 days from the last date allowed for notice of appeal. That's the same as current law for the Board of Civil Authority. Notice of time and place of the hearing shall be given by posting a warning in 3 or more public places in the municipality, same as the Board of Civil Authority. And by mailing a copy of such warning to the legislative bodies of such municipalities and to all appellants. So even though the town is not directly involved in this process, they are staying informed along the way. When conducting a hearing under this subsection, the assessment supervisor shall issue a written determination addressing all questions heard. This is the current process for the Board of Civil Authority. There shall be an inspection internally and externally. And there's an inspection report, this is what's done by the Board of Civil Authority now in 30 days. And so that inspection is done by the assessment supervisor or their staff before the assessment supervisor issues a determination. There's a provision, just like in law, that if the appellant decides, I don't want you in my house, that the appeal gets dropped because, well, we need to inspect, and if you won't let us inspect, then we can't make the change. There's also provision that's the same in current law that in an emergency situation, the inspection can be done electronically. And same thing, if the appellant doesn't cooperate with the electronic inspection, then the appeal can be dropped. I don't remember specifically, but this looks like something was added during COVID to me. Then the assessment supervisor has 15 days to, from the time of the inspection to issue their written determination. That's the same as current law for what the Board of Civil Authority has to do. They file it with the clerk of the municipality and with PVR. At the same time, they'll send a copy by certified mail to the appellant. And if there's any changes under the determination for the grand list, those will be made. I included the provision here that currently applies to the Board of Civil Authority, that if they do not substantially comply with the requirements of this appeals process, and if the appeal is not withdrawn, then the grand list value of the property subject to appeal shall remain at the amount set before the appeal change was made. In other words, if the assessment supervisor doesn't follow the process correctly, and doesn't give all the notice and process that's required for the taxpayer, then their value is going to stay what it was before, for the time being. For an appraisal made other than January 1st, I mentioned this before, sometimes the grand list gets tweaked during the year, maybe as some construction happens or some other events. So the person agreed in that situation can appeal directly to the assessment supervisor, and there's no grievance process for that. So within 14 days after notice, person agreed by a final decision of the regional assessment district may appeal and file objections with the assessment supervisor. Some of this is repetitive, but it's just to cover different stages in the process, in the appeals process. But again, the idea is to keep the same process as what the Board of Civil Authority is doing. So we have the process, that's the current process for an appeal to the Board of Civil Authority again. Same requirement for a written determination on page 8, line 9. And then subdivision 3, when all of these appeals have been determined, the RAD shall amend or correct the grand list to conform to those changes. One bit of feedback we might receive is under this new system, the role of municipal clerks and the role of the RADs in changing the grand lists. So I wouldn't be surprised if there might be some places in here where I may have gotten that role mixed up a little bit, where maybe like in this situation, maybe it's actually the clerk specifically that should be doing this. So I'm hoping to hear feedback from the department and the field about those things. But the idea is we're trying to keep it the same as current law in places that we can. And finally, if an appeal is pending and undetermined at the time the grand list is required to be complete, it's just saying the assessment supervisor needs to hurry up and finish that determination, and then the grand list will be amended. So really, this is current law. There's nothing really different there, except just having a provision stating like, hurry up, we gotta finish this grand list. That's the first half, right? That's all the assessment supervisor appeals. The next section of the bill here, starting on page 9, are appeals to the director and to Superior Court. When it comes to appeals to the director, one thing I was hoping to get to talk to you about is a municipality can appeal, right? And that's going to become important as the regional assessment districts are not part of the municipal government. The municipalities may not agree themselves sometimes, and it will affect their municipal property taxes, right? So they have that ability to appeal to PVR. We may hear feedback that under current law, we've got the Board of Civil Authority, right? And as far as I know, I don't think municipalities are appealing to the Board of Civil Authority very much. It's taxpayers doing that. I don't know if there will be an interest in having a change where a municipality can go directly to the assessment supervisor, or if that's something that's the people will want to do. But right now we're keeping, the same system intact, even though there's a lot of different parties involved with new duties here. So just flagging that. So yeah, these are appeals to the director. This is all substantially what's in law right now under subsection A of section 4461 of Title 32. Subsection B here is 4461 B and C. On or before the last day in which an appeal can be taken from the determination of assessment supervisor. an agent designated by the legislative body of the municipality in the name of the municipality on written application of one or more taxpayers in the municipality whose combined grant list represents at least 3% of the grant list, shall appeal to Superior Court from any assessment supervisor not involving appeals of the applying taxpayers. So this is the process to appeal a court. And there are fees involved, just like current law. That might be something that comes up. Whether those fees continue, because I don't believe that the department imposes a fee for other types of tax appeals. And we are making this system kind of more like that. So that could be a question of whether fees continue to make sense. Subsection C is what is current law under section 4463. Again, this is just laying out the process for appeals to the to PBR or a court. This is specific to PBR. Subsection D is another section of law that's being brought in, handling withdrawal of an appeal. And the process to be used to communicate that to municipalities. And then that brings us to, after all of these sections on process, we get to sub E, which is the appeal is not withdrawn, then the commissioner of taxes shall conduct a hearing. And this is what I was talking about before. This is change from the current system where it would go to the PBR hearing officers, part-time ones. In this case, it's saying that the commissioner of taxes will conduct a hearing, like it does with other things. Here's the provision that is under current law where stating that this will be a de novo hearing. It's going to be conducted by the commissioner now instead. We keep the law about the current law about establishing or terminating a homestead and house site, because that can go to our current system for homestead declarations and the house site value and how that goes into those calculations.
Kirby, could you just define what de novo hearing is so that we're all on the same page?
Yeah, that's what I was saying before. It's Latin for anew. So all of the decisions of the RADs and the assessment supervisors before are wiped out and looking at it fresh, finding the facts, interpreting the law, determining how the law applies. Also, no deference to what was said before.
And the appellant could bring in more information at that point if they choose to.
Right. They're not going to be bound by
What they did before.
Yeah.
We have just a couple minutes left.
Okay.
And certainly this is not the last time to talk about this.
Right. We covered the appeal stuff pretty thoroughly there. So I'll hit on what the rest of it. We have a section here for the $8.50 per parcel fee, moving that over to the RADs. I believe the Act 68 report stated that it's something like 3-point-something million. So probably not enough to stand up 12 RADs. That's just to give you an idea of what that means for funds available. The next section I have here is the equalization study that's changing it to January 1st. There's a lot more conforming changes to be done with dates, but this is the one that is the grand list date, January 1st. This ties into to the appeals from before. This is, the grievance, the informal grievances are their own section of law that's outside of the appeals chapter, so that's, what's covered here. It's changing the dates to match up with the January 1 grand list date, and it's, having the RADs responsible for those grievances, including some placeholder language that the RADs would hold these grievances for a minimum of 4 hours per day for a minimum of 5 days. That's not under current law. It's kind of up to the listers what they do under current law. There's no standardization. So just threw that in there as in case you do want to standardize when the RADs are going to be available to do this. And it, which could change from town to town as to what's needed.
Is that what?
Just, I think of access to justice, and I'm thinking the way this is divided by basically county, you have 100,000, I don't know how many people in one county, and then not so many people in the other. And then when I see this, you have 3 days a week, 4 or 5 days, whatever.
Representative Odie, I appreciate that. We are just trying to understand the bill for now, and we will have lots of time to dive into how we might
So I
want to
just
change
wanna
it.
Bring up the access to justice issue.
Thank you.
There's a section here repealing a provision from Act 68 that has not become law yet. I believe it's related to lister training. Since there won't be listers, we want to repeal that so that when we do make our conforming changes and everything, that we don't have Act 68 coming along later and changing it back. Right? So, and hopefully there's not too many more of those things out there, because that's the kind of thing that keeps me up at night. It's like, I missed something that's going to undo the law later. We've got a bunch of repeals. There's going to be more of those, but here's some big ones. The appeals chapter, because that's being replaced. Listers oath, names of listers being communicated to PVR. There's the start of some transition provisions here, such as funds being held from the per parcel fee being transferred over to the RADs. It might make more sense to transfer those. I drafted this fairly early. It may make more sense to transfer those to the Department of Taxes instead. And we have some provisions about PVR's ordered reappraisals and what it has to do under the law. So we've got one saying that any reappraisal orders that are out there will stop because we're going to have this new schedule of reappraisals coming. And then this next provision is that PVR may revoke any of its existing reappraisal orders. And the PVR will not order any new reappraisals. And then placeholder, this is currently the working effective date that I threw in for when the RADs would start. I have a section here that I don't necessarily love, that is giving Ledge Council the ability to locate and make conforming changes when we update the statutes each year. I would love to find all these now and get it done. So I'm hoping that we can be confident enough that by the time I go in and make the conforming changes on this, that we hopefully don't feel like we need this. But it's drafted, it's there. And so to let you know, it's just for us to update the language to line up with what this act is doing.
Thank you. Thank you very much. We will dive back into this, I think, next week.
We have any things that we noticed, Kirby, on language? Should we send it to you?
Are you kidding?
No,
Oh,
send it to him
Notice about what?
on language. And what we just saw, if we have any notes on language about correcting something.
Oh, yes, yes, definitely.
Do you have one more clarifying or?
Yes, one more clarification.
Is there anything that I might have missed about, I'm thinking about a property where the taxpayer appeals it, doesn't get the answer that they want. The select board agrees with the taxpayer and then reappeals the same property. Is there anything in there?
I would have to look.
Yeah.
It would follow the same process that's under current law.
Yeah.
That's the intent here. But yeah, I would want to double check for answer that.
Thank you.
Thank you. That was great. Julia, would you like to join us? Sure. So we are going to look at some data on grand list values, partially to lay the groundwork for learning about the proposed state guarantee. This presentation on grand list values, Julia is already scheduled to come back in next week to do sort of like a new updated round of it with different framing. So don't feel like this is your one chance to dive in here. There'll be new rounds of it next week. It's a really cool part of getting this work right. And we're going to go until 10:30, and then we're going to take a break until 10:45, and then we're going to hear about the proposed state guarantee. Good.
Thank you. I'm Julia Richter with Joint Fiscal Office. There is a slide deck which is posted on the committee page under my name. I'm going to go ahead and share my screen. So we're all looking at the same thing here. Is that okay? Yeah, okay. Is that an okay size?
I think that's a delightful sign.
Okay, great. So talking about some grand list analysis of the 5 proposed districts in the administration's proposal. I'm gonna go relatively quick because I know we have a tight timeline, but please tell me if I'm going too fast. A few notes that I want to make right up front here. One is that this is really solely reviewing the 5 districts in the proposal. So this is not including other parts of the proposal like the homestead exemption or other tax pieces of the proposal. We're using preliminary FY25 equalized grand list values. It's preliminary because it's not final, and it's very, very close to what is final. This is just the best, most up-to-date data that we have at the moment. As you all know, the term equalized, this is referring to property at 100% of fair market value, right? So if it were to be appraised tomorrow or reappraised tomorrow, assuming that 100% of fair market value, we know that the state equalizes grand lists to be able to compare from town to town. So that's why we're using equalized. It allows us to do this across the state comparison. And lastly, we're nonpartisan, so this is not an interpretation, should not be interpreted as a recommendation of the administration's proposal, rather just some information for you to start to dive into it.
And the 5 districts we are starting with, both the Education Committee and the Government Operations Committee on the House side, and imagine people on the Senate side too, are looking if 5 districts make sense compared to 7 or 12 or 20 or whatever. We will continue to get information from them and then sort of look at different district sizes in order to understand grand lists. Back to you.
Great. So we're going to briefly walk through the underlying pieces of the analysis, talk about the school district equalized grand lists, briefly touch on the ADM count, so the pupil count, each of the proposed districts, and then talk about the equalized grand lists per pupil count. And then there's a couple other considerations I've included here at the end. So underlying pieces of the analysis. We know Vermont's grand list. I know that Kirby was just walking through the reappraisal bill. So I don't want to focus too much on this, but I want to note here the FY25, the total equalized grand list is estimated to be a 122.4 billion. It's important to note that when we're talking about property tax rates, that's per every $100 of property value, right? So what I'm talking about here today is before dividing all of the grand list by 100 to apply the tax rate. just talking about value. And by comparing grand list value across districts, that allows us to gain insight into the property wealth of a district, of a proposed district, the amount of funds that could be raised locally on a certain tax rate. We know that under the current law and finance system that it uses a statewide equalized grand list. So the grand list value of a school district does not matter in the sense of the school district. Every school district can raise the same amount of funds for a certain tax rate. So really looking forward at the proposed districts with a caution that it's hard to compare against current law, because current law, the property value of a district does not matter for the taxing capacity of that district. So these are the 5 districts in the proposal. I'm gonna make this bigger for me. We know that the administration's proposal is to eliminate, part of it is to eliminate the supervisory union structure and consolidate the 119 school districts into 5 regional districts. So these are the 5 regional districts. The colors are corresponding with the long-term ADM, essentially the pupil count in each of those districts, but we'll have numbers that are a bit bigger and easier to read in a few slides. So getting into the equalized grand list per district or per proposed district. Essentially what we've done here is we've looked at each of these 5 proposed districts and said, according to where these proposed boundaries are, how much equalized grand list value falls into each of these 5 districts. And what we can see here is that the percentage share of the total grand list value, so homestead and non-homestead, really varies quite significantly by district, right? So we see the Champlain Valley region has the largest percentage, the total state grand list of 39%. And the Northeast region has the lowest percentage of grand list value at 9%. This is one metric. We're going to walk through a number of metrics of different ways to think about it. These districts have different pupil counts, right? So now we're solely looking at the grand list value of the districts. In case you appreciate pie charts, this is a pie chart. A little counterintuitive for me to put a pie chart in a presentation, but I know it can be helpful. So this is the same information that we have here, but solely just in a pie chart. I learned recently that in France they're called camembert from your chair. So anyway,
Did you find out what they're called in Germany?
I forgot to ask my husband, but I will follow up. But anyway, so in terms of total equalized grand list, this is the same thing, same numbers, but now just looking at it from a visual perspective. And in all of these slides, I've ordered all of the districts in the same order on every slide and color coordinated all of it. So Champlain Valley region, you can see colors, is always dark green. Now separating into homestead and non-homestead, we see that things change, right? Some districts have the same statewide share of homestead grand list and non-homestead grand list, while others have a larger share within one of the categories. So again, you'll recall there's 2 kinds essentially of property classes for the purpose of taxation under current law, the homestead and the non-homestead. So this is really just we were looking at the total and now we're separating the total and saying homestead and non-homestead. So for instance, you can see that Champlain Valley has within the statewide grand list, homestead grand list, it has 46% share, whereas within the statewide non-homestead grand list, it has a 33% share. So starting to look at, it really does matter which grand list we're talking about when we're talking about taxation of a grand list. this is a summary slide. These are the percentages that you've already seen on the previous slides. I put them here to show exactly what I was just mentioning, right? The percentage share, the percentage of a district's share of the statewide grand list depends on the classification. So here looking, if we look at Champlain Valley, because it's on the top, that 39% of the total grand list share, 46% of the state homestead share or homestead grand list, and 33% of the state non-homestead grand list. Oh. Where are you?
What happened?
I don't know, but I'm just going back. So this is where we just were. Now moving on to long-term average daily membership. You'll recall that this is essentially on average how many kids are in schools, the technical term. So we're essentially looking at, how many kids are in each of these school districts. We just looked at grand list value of the school districts. Now we're looking at pupil count. Next, we're going to look at grand list per pupil count. But so long-term ADM is essentially the count of students in a school district. Take the average daily membership over 2 years, then add in state-placed students for the most recent of those years. And we know that in fiscal year 2025, which is the same grand list value that we're looking at right now, all of the modeling you're looking at from APA is also fiscal year 2025. We know that the long-term ADM is 83,368. Essentially, that's the pupil count. We also know that count has been declining over the years. So we're looking at a snapshot. And when thinking about it, across the proposed districts, again, we can see that the share of the state's pupil count also varies significantly across the proposed school districts. So we see Champlain Valley, again, has the largest share. It has the 41% of the state's total long-term ADM would be in this proposed district. And Northeast region has the lowest percent of the state's long-term ADM in fiscal year 25 at 12%.
Yeah. This is such interesting data. I'm not asking you to produce this, but is it easy to get longitudinal data on these areas? Could you look hypothetically to see how the state is changing in terms of the base and also the long-term ADM?
Off the top of my head, I think so. I don't see why not. And sometimes, you start digging around and you notice that there are things that you did not occur. I think that the most significant challenge would be depending how far back we're going when thinking about mergers and divorces. And so the crosswalk of the school districts.
Just don't do it right now.
Okay.
I'm just curious, because I think what you're highlighting is this is a snapshot of
Yes.
larger longitudinal changes that are concentration of population, but also opportunity, which is worth thinking about at the state level.
Absolutely. And the tax department, I know there's 2 tax department people in the room, has excellent grand list data. And a lot of it is posted publicly. So my largest consideration is mergers, but yes, absolutely.
Let me think about it. Don't do
So same colors, same pie chart. This is what we're seeing now in a visual for pupil count. And yes, I think it is very important to keep in mind, and I think this is one consideration I think I added on the final slide of we're looking at a point in time. And so we're not looking into the future. We're not looking into the past. So now we've looked at the total grand list, total homestead, non-homestead by the 5 proposed districts. We looked at the pupil count of those districts. And now I've put together the equalized grand list per long-term ADM, right? So essentially taking the grand list value and dividing it by the long-term ADM. It's one way to compare the spread across school districts. It's considering both the grand list value and also a higher or lower concentration of students in that district. So what we're looking at here is, again, the total equalized grand list. So this is homestead and non-homestead across the 5 districts per their long-term ADM. And what we see here is the ratio. Let me take a step back. So when I say the ratio from the lowest to the highest grand list per long-term ADM, essentially that's dividing the highest by the lowest to get a sense of spread. How different are the two? So what we're seeing here is the lowest grand list per long-term ADM of the 5 proposed districts is the Northeast region, and the highest is the Southeast region. Interestingly, it rounds to 2.0 or 1.99 in terms of the ratio of the lowest to the highest spread. I've also included here the median of the districts for the total grand list value per ADM, long-term ADM. And you can see in this instance, it's Champlain Valley if we're looking at the total equalized grand list.
That's so fun. Thank you.
Oh, I'm glad. I think it's fun too.
Has big implications.
Yeah.
We aren't even talking about.
I know.
Yeah.
So many questions,
Yeah.
but I'm saving.
I have, I think, like maybe 3 or 4 more slides. I am trying to move quickly to save time for questions. So then I did the same thing for homestead and non-homestead. We were just looking at total, and now we're going back into the classifications that we have. And interestingly here, we see the shift of comparison change from homestead, from total to homestead to non-homestead for some of them, like highest and median. So looking here at homestead, again, this is the homestead grand list of a school district, proposed school district, divided by its long-term ADM. And what we see here is the highest is Champlain Valley, lowest Northeast, and median is now Winooski Valley when looking at homestead. Also here we see that the ratio is now different if we're only looking within homestead. The ratio calculated the same way, highest grand list per long-term ADM divided by lowest of 1.6. Then moving on and moving into non-homestead and doing the same exercises that we have done with the others, we now see that the median is Southwest and the highest is Southeast. And the spread there, that ratio from the lowest to the highest is 2.5. And then I've included here, no longer including numbers, but these are the same comparisons that we were just looking at of putting onto one slide, just seeing how it can shift depending on if we're looking at the total grand list, the homestead or the non-homestead, that the median and the highest are shifting across all 3 of the different ways of thinking about our current grand list. Which is, I think, really interesting. But
I think that the furthest right-hand column in the bottom, I think the Southeast region was highest for in the previous slide.
Oh, okay. Thank you.
Yes.
Yes.
Thank you. I will make that change. So a couple of considerations that I think we've talked about briefly, but I wanted to note again is that this is representing student counts and grand list values for FY 25 and is not addressing any changes to valuations or student counts in future years. We know those will change. How they'll change will depend in part to a number of different factors, economic shifts, demographic shifts, policy shifts. And we know that those changes may not be uniform across the state, right? So some districts may be more impacted in future years than others. And the other piece that I also wanted to note is that this is not considering any sort of variance in the grand list within each of the districts. So parcel counts, range of property values. I didn't talk about that at all here. This is just looking at the entire aggregated district. And that is all I prepared for today.
Thank you. That's so interesting. And I just want to observe, this goes back to the question I was trying to ask you, Jake, because tax policy actually shapes this. This is in part a function of larger trends around concentration of opportunity to despair, but it's also about our policy and how that shapes how people respond. So I guess the takeaway for me is also to be extremely careful because the decisions we make this year are going to have a profound impact on the future and the viability of the state.
One piece that stands out for me is I think, even, the difference, even the transition between Act 60 and Act 68, 2 years later, I can't even later say, years later, that was right. There's always a conversation about what are we using homestead and non-homestead? Are we keeping them uniform? Are we not keeping them uniform? What are the implications of keeping them uniform and not uniform? Those decisions, when you look at them just statewide, are very different than if you look at them on a district by district basis. And that's, I think, really helpful too.
Yes. And incentives may be very different on a regional basis.
So yeah, go ahead, Representative.
I'm not sure we have time, but I'll
Okay.
just say to start with, yes, things that we can control, like the tax rate, maybe those will cause these figures to change. But also there's a bunch of stuff that we can't control. At breakfast this morning, one of the senators told me that the estimated student population in the year 2030 is in the 60,000s. That there's going to be a drop because no babies are being born. And so we can't control that. And I just think I'm worried that all this data is short-sighted because we're dealing with what's now. And I haven't seen anything yet that looks at what it is 10 years from now.
So I do fear we're veering into discussion and not asking Julia questions here. I've asked her to come back next week with sort of some more demographics on those district shapes and looking at different district sizes and shapes. So moving to sort of a 12 district that the education committee is starting to look at. So thank you very much, Julia.
It's a heavy lift.
Yeah.
We are going to take